Canavan.
Thank you, Madam Acting Deputy President. I rise also to speak on the Migration Amendment Protection and Other Measures Bill 2014. While this legislation is quite technical and procedural, I think it is very important because it provides the legislative foundations to support the government's response to the very difficult challenge of asylum seekers. And it is a very difficult challenge. There are no easy choices in this debate. And I did speak on the bill that was passed just before we rose for Christmas last year as well. And it is a difficult issue. We do want to provide protection to those that do need that protection for political reasons. But of course, we can't take everybody. And as soon as you have a gate that is open, some people will choose to come to this country for reasons other than political protection. And we need to have protections in place to ensure that the limited number of refugee visas that we can allocate each year actually go to people seeking political asylum. I note that Senator Hanson-Young is contributing to this debate when she's not even on her feet. She also said this morning that this bill will put Australia's ability to meet its international obligations at risk. Well, I don't believe that's the case, and I will cover that later. But I also note that during this debate there's been some claims about torture based on a UN report released last week, which I think has been rather discredited. The UN Special Rapporteur report on torture by Juan Mendez, issued last week, claimed that Australia is violating the rights of asylum seekers under the Convention Against Torture and other cruel, inhumane or degrading treatment or punishment. But the report failed to bother collecting evidence to support its claims about torture. We've heard from those on the other side of the chamber that Australia's system is comparable to that of Nazi Germany, which I think is disgraceful and completely out of order. Many fine words are also spoken about the need for a humane treatment of asylum seekers, and I support this sentiment 100%, but sentiment is not enough, because history has shown that we should take what is said, particularly on the other side of this chamber, with a grain of salt. On Thursday last week it was reported in The Australian that refugee boat activists have been were quiet under the LP but are now very loud that there is a different government in charge. And that article quoted celebrated human rights lawyer Julian Burnside believes some refugee advocates went easier on Labor than they should have, despite crowded and difficult conditions for more than 1,000 children in the lead-up to the 2013 federal election. Mr Burnside said that I suspect a number of advocates were a bit quiet when Labor was in because at least Labor were making the right noises. They ended up doing the wrong thing. And I think that what we've heard this morning is a classic case of this phenomena, that some in this debate like making the right noises without much regard for the actual impact and outcomes of their decisions. The families of those who lost lives at sea don't want us focusing on sentiment, they want us focusing on the issue. The many of thousands of children and families that were locked up under the previous policies want us to focus on the issue, not sentiment, because many people were defrauded and came here under false pretences that they could achieve a sort of sense of freedom and perhaps Australian citizenship, but they were sold lies. They were sold lies by disreputable people who seek to profit from a trade in people, and we should put a stop to that trade. And this government, I'm proud, through the policies it's implemented, has been able to put a stop to that trade. I'm prepared to support a government that is getting behind concrete actions that help keep in place the policies that have stopped drownings at sea and slashed the number of children in detention by 90% from the peak under the previous Labor government, and that number is continuing to fall. Now, this bill will continue to help implement those policies. As I said at the start, it's a technical bill that seeks to strengthen some of the or close some of the loopholes that exist in our regime. The bill seeks to amend the Migration Act 1958 to strengthen the efficiency and integrity of the process by which Australia determines the protection status of onshore refugees. On the final sitting day last year, we in the Senate here passed the Migration and Maritime Powers Legislation Amendment, resolving the Asylum Legacy Caseload Bill 2014. I've only been here for about 8 months, but it was a very important piece of legislation, and I know that it took a fair amount negotiation and caused a fair amount of heartache, particularly for members of the crossbench. And the bill was passed with the support of the Palmer United Party and Senators Day, Lionel, Muir and Xenophon. They, on that side of the chamber, did decide to do something instead of just seeming to do something. It was a difficult decision for them, I have no doubt about that, but it was the right one, and it's contributed to policies which has helped to stop the trade in people across our borders. The bill the government passed last year, with their help, re-established temporary protection visas. It has had the ability of getting children out of detention on Christmas Island because it fast-tracked a system to do so. The legislation before us is needed to make this legislation we passed last year to work as it should. It makes a number of amendments to enhance the efficiency and integrity of our onshore refugee protection status program. It clarifies the responsibilities of asylum seekers to provide and substantiate claims in relation to protection visas. If asylum seekers do not cooperate with the government to establish their identity, they will not be given the benefit of a protection visa. This is in line with amendments to legislation in the United States, the United Kingdom and New Zealand. It will remove a loophole in the process that currently allows non-genuine asylum seekers to exploit the independent merit review process. Refugees can at times game the process, or potential refugees I should say, refugee seekers, can game the process to present claims of new evidence or claims to bolster their original unsuccessful claims after they learn they were unsuccessful. This causes significant processing delays for other genuine applicants. The bill will also create the grounds to refuse a protection visa application when an applicant refuses or fails to establish their identity, nationality or citizenship. Establishing an applicant's identity is vital for making a decision to grant or refuse a visa. An individual's identity, nationality or citizenship can have a direct bearing on whether they engage Australia's protection obligations. These provisions are important then for this reason. It is in the interests of all Australians and all genuine asylum seekers to discourage the use of bogus identity documents, to discourage the destruction or discarding of documentary evidence of identity, nationality or citizenship by or on behalf of people seeking protection in Australia. Establishing identity is vital for the integrity of any immigration system for obvious reasons. It allows accurate assessment of a person's protection claims, particularly in a time of increased dual and multiple nationalities. The measures also help safeguard the Australian community from people who have committed serious crimes. Just to be clear, this bill is not about forcing people to come up with documents that do not exist. But what it does do is make it clear that protection visa applications must be made in good faith. So unless the applicant has a reasonable explanation, their protection and visa application will be rejected if they present bogus documents. It's important to note, however, the refusal power will not be engaged if the decision maker is satisfied that the applicant has a reasonable explanation for refusing, failing to comply or producing documents which prove untrue, and either produces the documentary evidence requested or has taken all reasonable steps to do so. And I think it's reasonable that we ask people that are seeking to come to our country to live under the protections and privileges and responsibilities we all have as Australian citizens to take reasonable steps to establish their claim. We of course understand that in the difficult circumstances that some people come to this country, they may not have all of the documentation you'd expect of most migrants, but it would seem to me that it would be a reasonable thing for our parliament to ask for people to take reasonable steps to establish their identity and to take steps to prove the claims that they are making. And therefore the definition of reasonable explanation is very important to the detailed aspects of this bill, and I want to spend just a bit of time explaining what a reasonable explanation will be under this legislation. A reasonable explanation for the purposes of this legislation can include no reasonable opportunity to present the claim. For example, an interpreting or translating error was made in the primary stage of an application. A change in the country's situation affecting human rights after the primary decision was made. New information relevant to the application that was not available earlier, for example, documentary evidence of their identity. A change in personal circumstances, allowing presentation of new claims, for example, a new relationship, a new spouse or a new child, with a person who has protection claims in their own right. Being a survivor of torture and trauma, where the ill treatment has affected the applicant's ability to recall or articulate protection claims, or the applicant is considered most vulnerable, for example, a minor, mentally or physically disadvantaged, or has a restricted ability to participate in the protection process. Those criteria seem to me to be eminently reasonable, and they feed into a process which will require reasonable explanations for claims under our asylum seeker process. Additional to these new protections, the bill also removes a number of statutory bars to implementing the government's fast-track process established in the legislation passed last year, and until we passed this legislation, the majority of the maritime arrival backlog, which is approximately around 22,000 people at the moment, living in the community on bridging visas, will not fit the definition of a fast-track applicant and cannot be processed as such. As I said in my earlier remarks, the legislation passed last year has played a significant role in fast-tracking the backlog of maritime arrivals who are claiming asylum. These are people living in circumstances which I think we all recognise are not ideal, and we prefer to process their applications as soon as possible. But we simply can't with so many people, and also with so many avenues for appeal and disputes to emerge, which hold up the process for everyone, including those that probably have genuine and applicable asylum claims. The bill contains a number of other safeguards and protections to ensure procedural fairness to protection visa applicants. Of course, decision-makers must act themselves in good faith, just as the applicants must as well, and fully assess protection visa applications and afford procedural fairness to asylum seekers. Decision-makers are also provided with guidance to be aware of the special needs of vulnerable applicants and to ensure appropriate support and consideration is provided. For instance, the Department's Procedures Advice Manual, gender guidelines and refugee law guidelines assist in assessing claims from vulnerable applicants, including women and applicants with an intellectual disability. Vulnerable applicants include unaccompanied minors, survivors of torture or trauma, and applicants who are physically or mentally incapable of taking full responsibility for their claims. Under the requirements of the Migration Act, decision-makers are required to act in good faith to fully assess protection visa applications and afford procedural fairness to asylum seekers. Vulnerable applicants will also receive help to present their claims, have the right to seek privately arranged application assistance, as does, of course, any person who is claiming protection in Australia. This bill also seeks to, as Senator Seselja said earlier, also seeks to restore the more likely than not threshold for complementary protection. There is no change in this bill to the threshold applied to the Refugees Convention. And I note that the Labor Party at this stage have indicated they will support other parts of the bill, but not those in Schedule 2, and those concern the more likely than not threshold for complementary protection. As Senator Seselja pointed out, this is a little strange, although we're getting used to it, that the Labor Party had a position in government, they have a different position in opposition. They seem to be have had a change in principle and attitude to the budget, to migration legislation, and they can't, in my view, always explain why, because in 2012 the Labor government introduced complementary protection provisions. They were inserted into the Migration Act in March 2012, and the more likely than not threshold was included in this legislation originally. It was stated in their policy originally, but was not followed through in legislation. So it was their policy in early 2012. It's now not their policy, I'm not sure what their policy will be on border protection at the next election, but if it's anything like their policy before the 2007 and before the 2010 election, it will mean a weakening of our border protection laws, potentially opening the gate again to more arrivals, more difficulties for our processing of applications, and more hold-ups for people that are actually genuine refugees around the world who are seeking to come to this country for protection. There is also evidence that this was the Labor Party's policy, because the Department of Immigration and Border Protection confirmed that between the 24th of March 2012 and the federal court decision on the 20th of March 2013, the Labor government applied the more likely than not test to complementary provision applications. So even though it wasn't in the legislation, it was a test that was applied in practice by the then Labor government. Labor even argued that the proper threshold was more likely than not in the federal court, but this was unsuccessful. So this legislation doesn't raise a threshold. It doesn't change a threshold that was applied. It simply seeks to clarify in legislation, to codify a test that was being applied in a policy sense, but the court ruled was not applicable. So, then that is the court's right to do that. But of course, this is a matter that we as a parliament can resolve that no, we'd like to look at these things in a different way, and we would like to apply a more likely than not test, and that would of course not provide for the kind of court decisions we saw in 2013. I said earlier that there have been claims made that this more likely than not threshold is not consistent with our international obligations, but it's an absolutely acceptable position under those obligations, and it's consistent with the thresholds that are adopted by other countries similar to ours in terms of human rights in our record, such as the United States and Canada. Specifically, the more likely than not, or sometimes called the more probable than not, threshold is reflected in the views of the UN Human Rights Committee in its General Comment 31 and the United Nations Committee Against Torture in its Comment 1 as to when a non-refoulement obligation will arise. The risk must be assessed on grounds that go beyond mere theory or suspicion, but does not have to meet the test of being highly probable. So it seems to me that there is quite a bit of evidence there that it is consistent with our international obligations, and that by passing this specific piece of legislation we'll simply be re-establishing the test that was applied in some years of the Labor government. It doesn't seem to me an overly controversial change, and I haven't seen any reason why we should change from that process. But this is not unusual, because the Labor Party and the Greens have unfortunately blocked or not supported almost any of the changes that we've tried to make to fix the crisis they created. It was during their time in government that we had almost, I think, or even maybe a little bit above 50,000 arrivals to this country and for people seeking asylum. Because of that, we have ended up with 30,000 of them when the coalition came to government with their applications unprocessed. We had almost 2,000 children in detention at the peak during the Labor government, and when the 2013 election was called, we had 1,743 children in detention. Now that was after the fact that in 2007 there was zero children in detention when the Labor government came to power, and we'd like to get back there, because I don't want to see kids in detention. If we don't have to, I want to make sure we have a system which processes people's refugee claims as quickly and as humanely as possible, but we can't do that unless we have a system which deters people from trying to abuse the system. We have a system that people can easily abuse and take advantage of. There will be no avoiding the fact of processing backlogs, and therefore, under the detention policies that both major parties support, a lot of people and children having to remain in detention. And it is a very, very good outcome that today we have fewer than 120 children in detention, and hopefully that can be reduced to zero over the next year or so. And this bill that we are passing today, or that we hope to pass today, would help achieve that, because it will free up our application process. It will make sure that people have to act in good faith when they make a claim, and will reduce the time and delays that are currently beset the processing of applicants for asylum in this country.